A very warm welcome to the ODPP Café. Thank you for joining us for this show this Friday. We are glad that you're tuned in to listen to us today. This show is brought to you by the Office of the Director of Public Prosecution, and the show is aimed at educating, informing, and just talking about how the criminal justice system operates and how we as common citizens can interact with it. My name is Anita Onuko. I'll be your host for today. The show is live on Facebook at the Office of the Director of Public Prosecution. We are also on YouTube at the Office of the Director of Public Prosecution as well. And follow us on Twitter at the Office of the Director of Public Prosecution _KE. Let us know what you think about our topic today and engage, ask questions. There are experts waiting to respond to you. And of course, I also have some experts on the show today. As always, I am going to start with some highlights from the courts. As just a few of them, like we keep saying, it's not exhaustive. It's just one of a few of the cases in courts that we want to talk about. So the first case is about a woman sentenced to 7 years for attempted murder. A Kibera court slapped a woman with 7-year jail term for finding her guilty of attempted murder of her boyfriend. I remember we talked about attempted murder when we were talking about murder cases. Ebi Khalea was convicted and sentenced by senior principal magistrate Philip Mutua after court prosecutor Violet Ombati proved the case against her. So Ebi attempted to murder her boyfriend in Kisumundogo within Soweto after a night of drinking spree that culminated in a confrontation once she arrived home. Her boyfriend, Michael Ngure, had to undergo surgery and spent several days at Mama Lucy Hospital due to the stab wounds. Khalea has 14 days to appeal. Again, we have discussed about appeals on this show, and definitely if you want us to discuss it some more, you can just suggest it to us and you can pick it up again. So Ngure didn't die, but Ebi is in for attempted murder. Of course, she has 14 days to appeal, so we'll still follow up on that case. The next case is about Samburu Governor Moses Lenolkulai. It's quite a mouthful, the name. There's a fraud case going on, but then he failed to stop the prosecution from using bank documents as evidence against him. Trial Magistrate Thomas Njoka said the objection by the governor that the prosecution should not use bank documents into which the county paid money to his account will not be allowed. The governor, let me not mispronounce his name, but then the Samburu governor, alongside 10 county officials, are charged with defrauding the county government of 84 million that was paid to his company, Oryx Petrol Station, for fuel consumed by vehicles owned by Samburu County. He has also been charged with conspiracy to commit corruption, abuse of office, conflict of interest, and unlawful acquisition of public property. The governor has since denied all the charges, so the case is ongoing. This was a case of corruption, and again, we had the anti-corruption team here discussing it, and there's that aspect of follow the money approach, and definitely this could be one of those, what is happening in this case. That's why the prosecution must use bank statements in this case. The next case is interesting. I never knew you could do this, but a man was jailed for refusing to reverse M-Pesa transaction. So we have the power, yeah? A man was sentenced for withdrawing and spending money that was sent to his M-Pesa account by mistake. This happens to most people, and every other time you're unable to pursue your money. But then this guy was taken to court. The prosecution submitted that Cyrus Nzioka received a sum of 16,463 from Harriet Karemi on November 3rd, 2020. Nzioka, however, who was not the intended recipient, declined to return the money. Half the time you're told fulize imekula pesa, pole bahati mbaya, or someone just uses the money and doesn't pick your calls. But at least you can take someone to court for this. Nzioka pleaded guilty, clearly accepted his mistake to the charges before Nairobi Senior Principal Magistrate Martha Nazushi, where he requested for leniency and forgiveness. The magistrate sentenced him to 3 months in prison or pay a fine of 20,000. Again, we've talked about fine, bails, and bonds. So he can pay a fine of 20,000 and go, or meaning he's accepted his mistake and he's paid a fine for it. Or if he doesn't have the 20,000, he's jailed for 3 months. So imagine trying to steal 16,000 and paying 20,000 as a result. The next case is about a man charged with being in possession of wildlife carcass. A man pleaded not guilty of being in possession of Dick carcass in Saikeri village in Kajiado. The prosecution submitted that Joshua Ladapash was found by KWS officers with the animal shortly after it was killed by his dogs. Just in case. Ladapash was released on 100,000 bond and an alternative cash bail of the same amount. The case will be mentioned on July 15th for pre-trials and setting hearing dates. We'll have to ask one of our experts here what happens to this evidence. I mean, it was carcass, how it will stay until 15th of July, how it will be submitted as evidence. Anyway, the defense, the next case is about the defense PS. He was sentenced to 6 months in jail. The High Court sentenced Defense Permanent Secretary Dr. Ibrahim Mohammed for 6 months in jail after he was found guilty of contempt of court. Justice Jairus Nga issued the sentence after the PS failed to obey court orders directing him to pay 5 ex-military officers 12.5 million for illegal detention during the 1982 coup. Wow. The 5 former servicemen, Joel Lekukuton, Joseph Yopsoi, Jason Liaryong, James Longipo, and William Seketian had been fired and detained for allegedly taking part in the failed coup. So as per the Constitution, contempt of court offense is punishable by a jail time of up to 6 months or a fine not exceeding 200,000. We'll have to follow through and see what the PS does in this case. Well, that has been the highlights of the courts this week. Of course, there's more, like I say, and we'll keep updating you as we go. Just as a heads up and what is happening at the ODPP next week, we will be in Lamu, and we'll be discussing access to justice. Tune in and see what's going to happen there. You know, Lamu is an how is that word said? Archipelago. And there's so many islands, and access to justice is a problem. So you'll see, we'll take you down to Lamu to next week to see what the ODPP has planned for the residents of Lamu and those around Tana River to easily access justice. Well, we get into the topic today, and it's not actually a topic today. We've been having this topic on Twitter and on Facebook, trying to just sensitize you about the rights of an arrested person and the rights of the victims. A lot of discussion on Twitter has taken place about what happens when somebody is arrested, or what happens when I'm a victim of a crime. What does the law say about me as a victim? What does the law say about me as an accused person? We've discussed this on Twitter. You've seen your comments. We've tried to engage you. But today I have in my studio, 2 experts, one from ODPP and another one from ICJ. I just want to give them time to introduce themselves. Today I don't have a lady. I have 2 gentlemen with me. So clearly I'll just start from my immediate, yes, karibu Vincent. And actually, ni mgeni kwanza. So mgeni wa ODPP ajiintroduce.
Okay, thank you very much, Anita. My name is Vincent Kimathi, a program officer, criminal justice and security sector strengthening reforms at ICJ Kenya. Okay. Yes, I'm happy to be here today.
Karibu sana, and we are happy to have you. Tunapenda wageni.
Thank you very much.
All right.
Okay.
Karibu, Mr. AKA Jonah. We start with the AKA, then now we go to Meroka.
Good morning. Thank you very much for inviting me.
Yes.
My name is Miranda Rights. I'm a prosecutor within the office of the ODPP. And I'm currently stationed at Kibera Law Courts as the team leader.
Okay.
Thank you very much.
Karibu sana. So today we're talking about the rights of the arrested person. Is it right to say right of the accused as well? Is it the same term? Accused and arrested person, is it the same thing?
No, it is not the same thing, because an arrested person, it is someone who's been taken by police officers and taken to police cells, and maybe they've been booked already.
So the case has started?
No, the case has not started. You've just been arrested. You've not been produced in court.
Okay.
Yes.
Yeah, so we are discussing the rights of the arrested person and the rights of the victim. And we just want to be sensitized as the public to understand exactly what are these rights? What does the Bill of Rights say about the arrested person? And what does the Victim Protection Act say about the victim? So maybe, Mr. Meroka, maybe just let's start with the journey of a suspect. How does it start?
Thank you.
Yeah.
For us to understand the processing of a suspect to leading to being an accused person, we start with at the time of arrest.
Yes.
And what is arrest? Arrest is a confinement of your restriction of movement for purposes of being suspected to having committed a crime. At this stage, all you have is to be informed that you are under a restriction for purposes of committing an offense. And who can do this arrest? One, we have the mandate under the National Police Service. They have unfettered discretion to effect arrest to prevent a commission of a crime. The second team of people who have the mandate to effect arrest are institutions that have specific functions for the protection of public health, public safety. We have the Public Health, we have the Anti-Corruption Commission, we have the Office of Migration, and many more, even Kenya Wildlife Service. They can effect arrest.
What is to effect arrest?
To effect arrest is to restrain a person, to restrain a civilian from either continuing to commit the offense or from running away from the crime that he has committed, and then bringing him closer to the wheels of justice to take its own course.
So, the public can actually effect arrest?
Yes, the public can effect arrest.
Okay.
The national government, through the Ngao, the county commissioners, and officers below him.
Who's Ngao?
The Ministry of the Interior, the Ministry of
okay,
Interior, or the Office of the President.
Yeah.
They can effect arrest for purpose of preventing a commission or an attempt to commit an offense. But the difference of them is that they must present this person to a police station for purposes of officers at the police station receiving the suspect and now making a re-arrest. Now, at that stage, we call it a re-arrest because it is a secondary arrest arising from other institutions. Now, it is at that stage that this person is retained at the police station or booked for purposes of processing.
Okay.
What does it require? What are his rights at that stage? One, he needs to be informed that he's being restrained. He also needs to be informed who is restraining him. The officers need to identify themselves that it is us, police officer number this, from this police station with the mandate to restrain you. And number three, at this stage, he has an option to seek for a legal representation.
Okay.
He can ask to have his own advocate in this issue. And when he reaches at the police station, it is also his right to be booked in. The reason for booking him in the OB occurrence book is to start having a sequencing of his detention procedure.
So being recorded in the OB is very important.
Being recorded in the OB is very important.
So the question is, when you say the officer must inform the person about why they've been arrested, who they are, and this is what you call the Miranda Rights. We hear them on TV.
Yes.
Even in Kenya, they're called Miranda Rights.
No, we don't call them though.
Yeah.
So, but they are the same.
Okay.
And what this helps, you might not get the full explanation of why it's happening, but you must get a snapshot of why you are being restrained.
Okay.
It is a curtailment of your right, and it's necessary that you be informed at the bare minimum that we have arrested you because so and so made a complaint that you stole his cow.
Okay.
Now, the reasoning why the more greater detail can be made at the police station. But at that level, all you need, the basic one for the rights of the suspect, is being informed who is arresting him, being informed that he's being detained, and a right to his representation. And more importantly, if he wishes to speak, that the information might be used against him or might be in his favor.
Okay. So Vincent, which background is different? Does this always happen?
Okay, I will say they don't. It is a fact, but the reality of things is in Kenya, most of the arrested people, they'll just be roughed up, taken to police stations, and in fact, we've had cases where most people are not booked. There are no OB numbers against them. So when they are in the police cells, when you ask why are you in there, you'll be told even you are not booked. So my understanding is we've seen a criteria where police cells are used as intimidation places. Where, for example, if I have an issue with my senior here, I can speak to my friends who are in the police force, and he can be
Holding to the
taken, he
cell.
can be held into cells
Yeah.
without even being booked. So I think it is a culture we need to work on. It begins, that is where violation of rights starts.
Yeah.
Because by the time you're restricting someone's, or you're refraining someone from freedom of movement, it shows already that you're already violating their rights.
Yes,
Yeah,
yes.
I think we need to work on that. And
Yeah, so we have the laws, but you're not applying it.
we have Anita, we have very good laws. Very good laws.
Yeah, I was in
But-
Kisumu just the other day,
Yeah.
and the joke, just before 7 p.m.,
Yeah.
the curfew, unaambiwa forget about your rights, my guy.
Yeah.
Kimbia nyumbani.
Yeah.
Kwa sababu it's like it's the worst mistake to ever tell a law enforcement, a person effecting arrest, that you have rights.
Yeah.
It immediately takes you into a different space.
Yeah.
Ile utajua haujui. What will make law enforcement officers actually apply the law?
I think first, it is, I think as a society first, we need to create that environment where there is a free engagement between the police and the public. And
Tough call.
actually, it's I will personally say, I will commend the police service, because it is they've started opening it up to the public.
Yeah.
Because nowadays I can see police officers, and there have been cases where police officers have been on record even speaking to the public. You remember during the post-election violence, there's that Kenyan
preaching
citizens.
peace,
Why
yeah.
are you people fighting your neighbors? This is not the right way to move.
Yeah.
I think those are part of the things that show that we're heading at the right direction as a nation. However, police officers need to understand that they work for the people, and their work is not oppressing the people. And for purposes of system in this country, we need to have a police service that is accommodative to the public. Because actually, if you need to understand that the police officers play a very critical role in the criminal justice system.
They're important actors.
In fact, they are the first people, they are the first organ, which is the right one to use. They are the first contact between the arrested person.
They initiate the process.
Yes.
Yeah.
So if the process is
Not
tampered
from
with
there.
from the beginning, then
Yeah.
Yeah,
I saw even Mudangari police station, they had like a Christmas party. And of course, it was met with a lot of skepticism, like wanajaribu, wanatafuta nani. And I think they were just trying to reach out. So we must
they're really trying, because
Yeah.
they are opening up to the public. It's a good thing.
It is.
Yeah.
So, Mr. Mcheka, let me ask you, I don't know if there's a right question to ask, but the accused person is concerned and maybe the victim. I mean, how do you interact with these two individuals?
Thank you. Maybe I just wanted to, before I answer to
Yeah.
that, there is a bit we missed of the obligation of the suspect.
He has an obligation.
The obligation of the suspect,
Yeah.
when informed that he's being detained, is to cooperate. And that is also a responsibility on him. We might, as much as we're discussing on the rights, it's also an obligation of the suspect to cooperate.
But you're being arrested. Why do I
Precisely.
cooperate?
The reason why you are cooperating is going to vindicate yourself that it is not you who committed this offense.
Yeah.
When you become militant, then either party will not understand who is at fault. So cooperation is really to their own benefit as well. And the reason why we are giving the rights is for purposes of knowing that this is your must do, but also you also have an obligation on the institutions, provided they have introduced themselves. It is pretty critical that that you also
suspect
cooperate.
Yeah.
Now, on the mandate of the ODPP, it is derived from Article 157, or through from 157.1 to 11. Generally, it is the Office of DPP that has criminal mandate of all. What does this mean? That it is the ODPP that initiates on behalf of the Republic, So when does this mandate start triggering, properly so called? It can start even when the arrest has not been made. the DPP has the mandate, upon receipt of a complaint, to write to the Inspector General for purposes of investigating a specific allegation and revert back to him on with the report of what has been transpired from the investigation. And it's on that investigation that then the DPP can make a decision whether this matter is of a criminal nature, and if it is so, then it can recommend that the charges be preferred before court.
Yeah.
So the mandate of DPP can start even before arrest. But when it comes, it triggers in after arrest. Secondly, I wanted us to mention the accused person, the suspect who is in custody, and what is his rights for purposes of the DPP triggering his power.
Yeah.
Has an obligation to record his statement. The accused person, the suspect, has an obligation to record his statement. Why is that statement important? So that as the police are compiling a file, which was the victim or the complainant side of story, we can also get to a glimpse of what is the defense of the accused person or the suspect. And it's at that stage then, when that file is prepared and complete, it is brought to the DPP to reassess the evidence. And if the evidence meets the standards of within the parameters of the ODPP, the threshold test, the public interest test, then the DPP can make a decision that this matter is fit for it to go to court. To meet the threshold, the DPP has the discretion to revert it to back in to either cover further investigation or to recommend the closure of the file because the evidence does not meet the criminal threshold, which the ODPP has a standard for.
Yeah.
To give that information. When do you need to give it? Do recording of statements at the police station. At that stage, you also have to call in the recording of statement. You also have a right not to, but if you choose to record a statement, then I've given a reason why it favors. Not necessarily that you are going to incriminate yourself, but you can present a version which was not within the purview of what the complainant brought out.
Yes. So at what point, just to cut you short, at what point does the DPP or the ODPP engage with the victim now?
Now, that's why I'm saying that after that stage, the file will be presented to the DPP. The file presented to the DPP will also have the version of the victim. It is through that version of the victim and all other evidence in the file that will make the DPP make a decision to prefer a charge. So the first interaction is already there.
Yes.
But that does not mean that it will be the only interaction with the victim. Subsequent to a trial, the victim has an access to the prosecutor throughout to know the process of his matter, to be prepared as a pre-trial of what intends, how the evidence will be presented before court, and how we need to structure it in the manner of presentation. So the victim has